afternoon, ladies and gentlemen. Thank you for joining us at this last session and for not going into the weekend right away. We are still waiting for one speaker, actually. Our French colleague, Stéphane Brabant, got lost and didn't find the building, so we hope that in the course of the session he will join us. And we might actually change the order slightly, but let's get started. May I introduce myself? I'm actually chair of the Corporate Social Responsibility Committee of the International Bar Association and also of the Council of Bars and Law Societies of Europe. And I am actually an attorney at Dentons. To my right is Lucy Scott Moncrieff. She is president of the Law Society of England and Wales, and she will introduce us into the subject of corporate accountability and human rights. The second, any problem? No? Okay, this is the Russian translation. Okay, can we close the door someplace, because this is really disturbing when it's so loud, the Russian translation. The second speaker will be, hopefully, Stéphane Brabant. I will introduce him once he shows up. Our third speaker will be Mikhail Popov. He is Vice President Legal Affairs and a member of the board of OGSC National Aggregates Company, and he will speak about corporate governance, transparency, and shareholders' rights. Our fourth speaker will be Tatiana Gorovaya, Legal and External Affairs Manager of Nissan Corporation, and she will speak about Nissan's corporate social responsibility strategy. Our fifth speaker will be Andrei Bushev. He is General Counsel for Russia and CIS for International Paper and Associate Professor of St. Petersburg State University. And he will speak about state responsibility for private actors' behavior. Does corporate accountability imply public function in a human rights protection? And our last not least speaker is Sergei Kiselev, Vice President for Corporate Affairs and Communications, GTI Corporation, and he will speak about corporate philanthropy and government regulations and the new restrictions for the tobacco industry. Welcome, Maria. So thank you very much for joining us. And I would suggest that we dive right into Lucy's presentation. Lucy has to leave in the coffee break because she has to go to another panel. I would like to invite you to come up with questions right after the speeches. We'll take Lucy's questions all because she has to leave. Otherwise, I would like to restrict the questions to 1 to 2 after the speeches directly, and in order to save hopefully some time for the discussion in the end. So welcome again. Thank you for joining us. And Lucy, you have the floor.
Thanks very much. Can you hear me properly with my, is that the right distance? At the Law Society, we quite often run training programs on human rights law. And there's usually a few young lawyers who come up to me afterwards and say, I really want to be a human rights lawyer. How do I get to be a human rights lawyer? And my response to that is, well, it used to be, you're almost certainly already a human rights lawyer, because human rights gets into all areas of law. And if you're working with individuals, particularly if you're working with vulnerable individuals, then it's very likely that what you're doing involves human rights. More recently, I've been able to say, whatever sort of law you're doing human rights law. And the reason that I can now say that is because of the adoption by the United Nations of the Ruggie Guiding Principles on Business and Human Rights. There are 3 principles. The first one is the state's duty to protect against human rights abuses by third parties, including business enterprises, through regulation, policy making, investigation, and enforcement. The second guiding principle is that there is corporate responsibility to respect human rights. So businesses must act with due diligence to avoid infringing the human rights of others and to address the negative impacts with which they are associated. And the third principle is that there has to be access to remedies. The state has an obligation here. They have to provide remedies, and businesses also have to provide remedies through grievance procedures. And any non-judicial grievance mechanism needs to be legitimate, accessible, predictable, rights compatible, equitable, and transparent. So, all very interesting. That's all to do with businesses. What's it got to do with lawyers? Well, what it's got to do with lawyers is twofold. Firstly, we all work in businesses, even in a private practice is a business, or we're working in-house, or working in government, which is also bound by all of this. But of course, more importantly, very many lawyers are advising businesses. There are very few businesses that don't have some kind of legal input in them. And it's those businesses that need to be advised in relation to their obligations and their issues in relation to these principles. So you need to know, if you are working for businesses, if you have business clients, you need to know about this stuff because it's part of your responsibility to be able to advise your clients. It's true to say that the Ruggie principles are advisory, they're guidance, they're not mandatory. And Professor Ruggie, when he was presenting the principles in 2011, said, "The guiding principles' normative contribution lies not in the creation of new international law obligations, but in elaborating the implications of existing standards and practices for states and businesses, integrating them within a single, logically coherent and comprehensive template, and identifying where the current regime falls short and how it could be improved." So, not mandatory, but what he's saying is, it's all there already. This is just bringing it all together and putting it in one place where people can find it. So I'm not going to talk about law businesses' responsibility, sort of direct responsibility, because I think that's something that people can work out for themselves. I think the really interesting issue here is what effect all of this has on the lawyer-client relationship. And the big question that, or the first big question that law firms need to ask themselves is, should we be acting for clients with a poor human rights record? And I'm just going to take an example here. There may be a business that is running vulture funds, where the business targets countries which are getting international debt relief and buys up their debt before it's written off, and then buys it up at a discount and then tries to get back the whole amount from that country. Now, that may be very smart business, but actually it's breaching human rights provision because that is taking money that would otherwise be used for the necessities of life, for the individuals in that country, for health, for sewerage, for water, for food, for good governance. And so the very act of engaging in that process is infringing the human rights of the people in that country. So should the lawyer be advising that company in how to get that money or in other things? And I think there are a number, when you're looking at should, there are a number of different aspects to look at. And the first one is your own reputation as an organisation. Because if you are acting for businesses that are seen as disreputable and disgraceful, then how much of that rubs off onto you? You may have other clients that will not be wanting to be associated with you if you are associated with this other organisation. One of our big firms in London did a survey of their 100 biggest clients and established that 2/3 of these clients, big corporate clients, had their own human rights policies. So those firms are going to be wanting to look at their lawyers to make sure that they also have good human rights policies and then they're not betraying those policies by acting for disreputable organisations. So first of all, there's the client issue. Secondly, there's a government issue. Very often government tendering, certainly in the UK, is designed to try and promote good behaviour, and so there are certain barriers to being able to tender. And it may well be that not being able to have a sort of clean pair of hands in relation to human rights could be a barrier in that way. In the UK, the attitude of the public and the politicians towards the place of business in society has hardened quite considerably since the banking crisis. And there's now a lot of scrutiny about the way big business behaves, and their professional advisors are getting drawn into this. We have a parliamentary select committee, the Public Accounts Committee, which is looking into tax evasion. And so they get the big companies up who they think aren't paying their fair share of tax in the UK and give them a grilling. But then they've also started getting their accountants up and giving them a grilling. You know, what are you doing, sort of creating these tax evasion vehicles? And so, you know, these accountancy firms are being very much in the public eye and being, you know, on TV, being torn off a strip for their work for these particular clients. And we think that some of the big law firms are going to be the next ones up to be giving evidence in front of the committee. So there are real reputational issues involved in acting in certain ways, acting for certain clients, which firms need to be aware of. I mean, it's their reputation, it's their choice how they deal with their reputation, but they certainly need to be aware of it. But then, let's suppose you say you are going to act for a client, you really need to be able to advise them very, very carefully, because although, as Professor Ruggie said, these principles are not binding at the moment, human rights law in various countries that are signed up to international treaties is binding. And you need to be able to advise your clients as to whether activities that they're undertaking may in fact be human rights abuses that could actually crystallize into real legal liabilities. So you need to know your stuff as far as that's concerned, because otherwise there could be a comeback on you with an action in negligence against you for not advising them on the risks that they run, because that's a large part of the job, isn't it? It's the being a trusted advisor, being able to understand the risk, being able to warn your clients about the risk, and that's a real risk that you need to bear in mind in considering. Well, you need to know about this stuff so that you can help your clients. But then, of course, there's the very positive angle on all of this, that for the firms and the organizations that do want to be compliant, that are interested in human rights compliance, you can help them enormously by advising them on how to become compliant. And we reckon that the main areas that where the people are at risk, where businesses are at risk, is first of all in their supply chain, because you have to use due diligence all the way down the line, and secondly in their employment practices, where of course discrimination issues come in, and you have to be very careful. They have to be careful that they're compliant as far as that is concerned. And lawyers have a major role to play in helping organisations to formulate a sort of overarching human rights policy, and then in helping them to design specific policies to deal with these areas of the supply chain and employment practice. And then thirdly, helping them to devise compliant grievance procedures, so that if somebody is saying, well, my human rights, or a group of people are saying my human rights have been breached, then you've got a procedure that will comply with the principles, will comply with the redress principles of Ruggie. And it's up to us as lawyers to help people to do that, so they've got something that is all fitting together. Now, it's all fairly new. 2011 doesn't seem that long ago, but not a huge amount has been done in the legal field. There are other parts of commerce and industry that have been really sort of getting on with this. Mining and resources industry, employment and recruitment agencies, information technology, oil and gas. These industries are actively working towards implementation of the principles, helping their members to be compliant in this way. But we need to get on with it in terms of professional services as well. We need specific guidance for lawyers so they know how to help their clients, so they know what they need to be thinking about in deciding what advice to give. And also, of course, in terms of their own businesses. So how do we advance the awareness and the debate? First of all, it needs to become a part of core legal training. An understanding of business and human rights should be part of core legal training so that young lawyers are aware of this as a sort of essential ingredient of the sort of professional mix that they can offer to their clients. We are also working in the UK, we're working with fellow bars around the world to raise awareness of the principles, because there are places that really haven't really heard of them, haven't really sort of started engaging with that. We're seeking funding from the British government at the moment to work with bars in Africa and Latin America on a project to raise awareness so that they can, with their members. And of course we are trying to raise it with our members, because I wouldn't say by any means at all that all our members in the UK are aware of these principles, are aware of the significance of the principles. So there's a lot of work to be done. There's a lot of thinking to be done about how we give the guidance, what sort of guidance we give. But we do think that those firms that are able to take on board now that this sort of stuff is interesting and important are going to have a bit of a competitive edge against some of their colleagues. As I said at the beginning, anyone working as a lawyer is working in human rights. So as one human rights lawyer to a room full of human rights lawyers, thank you very much.
Thank you very much, Lucy. I would like to comment a couple of things which you have raised from my perspective from the CCBE CSR committee, because there are a couple of things which probably need deeper thinking. And one thing is actually that human rights are addressed to states, meaning that you need actually implementation by legislation, by administration, adjudication by the states in order to know what the human right in a concrete situation means. They are usually not self-executing, and they are not to be actually looked at like a recipe book. You look it up and then you know what you have to do. But the devil is actually in the detail. How do you define the material standards? What does actually a human rights convention like the UN Convention or the European Convention really mean for a specific sector, and who defines that? And this is actually a discussion we are starting to have in the CCBE, because it is not easy. And the European Commission has actually asked to NGOs to come up with suggestions for oil and gas, information, communication, and personal agencies. But this is also not an easy question from a democratic point of view. Who is going to define standards and telling business what exactly they have to do? So we are actually starting that discussion, and this is one of the issues which need more in-depth investigation and also consideration. And I also know from certain bars and law societies which are represented in the CCBE that we have a pretty wide range between pretty progressive bars and pretty resistant bars who do not want to have additional restrictions and additional ethical rules on the bars, because they feel that what we have actually in legislation is sufficient. So we are heading and embarking on a very lively political discussion actually concerning the legal profession, because one thing is for sure, the legal profession will be hit because of the supply chain. The clients come up and ask actually their lawyers to sign their codes of conduct, which they cannot do, because when you have the second client coming up to ask you to sign his code of conduct, you have two contradictory things, and the code of conduct usually shall apply for the entire firm with regard to all employees and all matters. This means with the second client with a slightly different code of conduct gets you into breach of the client contract. So there are really serious also legal discussions we have to have, both in terms of the supply chain issue. We cannot sign that, but what is our answer to this type of requests from our clients? And we have a second thing, this is that law firms and also bars and law societies are qualified to be enterprises under actually the respective rules and so guidance documents as promulgated by the United Nations and other bodies. So the discussion is starting. Any more questions actually from the floor? Just excuse me for this brief comment. Maybe something where you stand, whether there is anything, any discussion going on in Russia. Has anybody any clue about that?
How many of you had already advised your clients on the Ruggie principles?
Who knows at all about Ruggie? Let's put it that way.
Hooray! How is it for you?
It is not so widely understood, I understand.
Do you want the microphone?
The microphone, please.
Here, law firm, a Russian law firm, Threefold Legal Advisors, as a partner, and one of the areas where we specialize and would like to promote is exactly business and human rights. And well, honestly, this is a brand new topic here in Russia, and the awareness is very low. But we've studied this issue in quite detail and studied all the guiding principles and all the documents developed to date. And we're now proposing Russian businesses to implement those guidelines and to join international initiatives. But so far, this doesn't sound exciting to most of Russian businesses, but hopefully we'll manage to make some change in this direction.
Add one thing, we also have concerning vulture funds, what you have mentioned, the question, according to our understanding of the rule of law, every jerk is entitled to a lawyer. So even a murderer is entitled to a lawyer, which is one of the heaviest infringements of human rights. So there we are also embarking on one discussion. Is this really the right thing to exclude a certain category of clients, or to exclude certain categories of how do you measure whether somebody has a human rights violation someplace on earth? How do you find out about that? Do we really want to embark on huge bureaucratic exercises concerning due diligence? So there are also a number of practical questions, and my understanding is also even with German enterprises, that a lot of them are very reluctant because they just don't want to have this enormous bureaucratic burden. But a lot of them are also, and I think this is the more important point, very much concerned about their reputation. This is a real issue.
Yeah, I mean, it's true that every jerk's entitled to a lawyer, even a murderer, but they're not entitled to a lawyer to help them be a murderer. And that's a distinction that I think we can draw. The distinction is there, isn't it? That if you're helping someone to do something that is in breach of human, you have to be satisfied that it's going to be in breach, then I don't think it's the job of lawyers to help people in that way particularly. But I do realise that there are different views on that. And it's going to be a long, slow process. And personally, I think that the first thing that firms should be thinking about is not whether they're going to have to go through this enormous bureaucratic process, but their own reputation and their own insurance premiums if they're paying insurance. These are the things that concentrate the mind, really.
Yeah, there was one more question.
Thank you very much. This is more by way of a brief comment to this excellent explanation about the Ruggie principles. I work for the European Court of Human Rights, and I just wanted to say that already there are quite a number of cases where states are held responsible for the violations of international corporations, particularly violations which give rise to environmental damage for which there's no national remedy. So already, amongst 47 member states of this important treaty, there is the possibility of companies being held indirectly liable. Of course, companies don't have any international responsibility, but the more states that are held responsible for corporate misfeasance, the more likely it is that the Ruggie principles will be implemented.
Thank you for that comment. There was another hand. Did I see one? No? Okay, then, do you want to comment some? No? Okay, fine. Thank you very much. Then, in the meantime, our French speaker has arrived. Welcome, Stéphane. I would like to introduce him briefly. Stéphane Brabant, partner at Herbert Smith in the Paris office. Stéphane is an expert in the oil and gas industry, in particular advising widely in Africa and Asia. And he will speak about corporate accountability and human rights in the oil and gas industry. Stéphane, the floor is yours.
Yeah, for how much time? Okay. I'm sorry I was very late, and my wife always tells me never travel alone because you'll get lost. And I've been lost because my wife is not there. So sorry about that. Next time I'll come with her and I'll be on time. So far, sorry for being late. In fact, I'm going to change my presentation because I realize that many of us are going to say some things. And I don't want to say badly what Madame la Présidente has said in a wonderful manner. And being from a law firm, and on top of that, being a Frenchman in a British law firm, I feel a bit shy, and you know, I feel bad with that. So I better be careful and try to represent the firm the best as possible. So, Madame la Présidente, excuse me for my poor accent. I'm not an English person. In fact, the life of lawyers, as you very well say, becomes more and more complex. You are absolutely right, especially in energy. So far, I remember I was in a conference one day, I was speaking of human rights and corruption, and there was a guy from a major oil company stood up and said, Stéphane, shut up. Please tell us about applicable law in that country of Africa or that country of Africa. Don't tell us about those principles of law, principles of whatever, that sort of soft law. We don't care about that. We want to apply the real law. And I told that guy, it was 10 years ago, well, we'll speak again in about 10 years. You'll see the difference. I'm sure that in 10 years, you would be ashamed of telling what you said. The guy eventually called me up, and he said, you were right, Stéphane. But we were not that many lawyers to do that sort of approach of things in energy. So indeed, it becomes more and more complex. Working with Africa, you may anticipate that we face about everyday issues of human rights. Not those human rights that we understand as a classical human rights. The human rights in international agreements, in all agreements. It means, as has been very well said, I won't detail, the right to dignity of the people. That's what Ruggies said. It is all to do with dignity of the people. So the right to education, health, safety, the right to a clear environment, all those sort of rights, which make it quite vague, quite large, but very, if not legally compulsory, we would say, and we will see that it is not an excuse not to be very much compulsory. In fact, companies now have a new role to play. Indeed, especially in countries like Africa, we all know that there's a problem of governance. The people, they expect so much from the government. The government failed. So what they do? They expect very much from companies. So international law, which used to apply to states, now it applies to some extent indirectly to companies. This is where we stand today. So there is a big shift. There was a film that has been sponsored by the IBI, which was called The Only Government We See. What does it mean? That film was a film of Chevron in Nigeria. And the film was all about to say that the population, they expect a lot from the governments. But since the governments don't deserve what they have to do, they look at the companies. So this is why the only government we see, what is it? The companies. And so there is some sort of an issue for this. There is an overlapping, despite it cannot be overlapped for legal purposes. Of course, I don't want to be too much legalistic, but here, in fact, it proves that companies have a real duty. That duty is all in what we call soft law issues. Those soft law are certainly the highest standard for company on how to behave. That's the highest standard that the companies cannot escape from applying if they want to have a successful project on the long term. This is clear. Not a single oil and gas companies or mining companies can be successful if they don't pay a very careful attention to all those issues, which are complex issues. In fact, they can be, all those regulations and declarations can be a very good tool, and sometimes they even become hard law. But before being hard law, we speak in our language of lawyers of what we call soft law, which seems a bit bizarre. A law is a law, it should be a law, it's a law. But no, we now make a distinction between hard law and soft law. But this is something which is, for me, and this is a clear message. It's soft law, and as we say, it's not to go before the courts. I'm not sure it's true anymore. It's not to go to before arbitration. I'm not sure anymore. And that soft law imply, believe me, and for all people involved now in companies, very hard sanctions. And this is why lawyers have to be involved. First in their advice to the companies, and also because law firms are entities themselves. And as Madame la Présidente said very rightfully, lawyers ought to know that new principles in order to provide a good advice, not only in the law applicable to the project, but also on all those principles which will make the project a long-term project. Because that soft law, it implies very hard sanctions, such as the reputation. Reputation, you say, oh, Stéphane, reputation, we don't care. Of course we care. The stock market will play with reputation. If a company is doing badly, and if it is in a newspaper, then the price of the shares will go down and could drive the company to bankruptcy. Reputation for getting the best employees, the best people, for having access to market. Also, very hard sanctions in terms of access to capital. And this is all to do with bankability of a project. Today, if you want to be financed, especially international financed, and you want to go to either international institutions or whichever commercial bank, they will have as a rule for you to apply all those principles of human rights. Otherwise, you take the risk, high risk, not to be financed. Can we say it is not a sanction? It is a very hard sanction, even if the base of their reasoning for the banks is going to be soft law. Sorry for translator if I speak too fast. I will try not to speak too fast. You do a great work, you know, translators. It's difficult for you. Sorry. Also, not to apply human rights can be very bad for the operations. You've seen in South Africa the landmine issue where you got 34 people killed because some basic human rights have not been applied and you get disruption of all the activities of the company. Isn't it a sanction if you have to stop to operate for more than a month? Also now, it goes above than that. If you don't apply those principles, that will go to extraterritorial claims in the US court as the ACT court. The court in the US pursuant to ACT regulation, which is the Act of 1789, which permits the court to go against the company in violation of certain principles in certain conditions. We will discuss that. It is very technical with a Q-Bell decision. I want to go into details. But the risk is there. That's the same before English courts. I don't want to go into details. I feel ashamed not being an English law lawyer to speak of English courts. But I must warn you that indeed there are some conditions upon which a court in England could hold the case and have a case pursuant to human rights against a company. Also, it goes even further than that. In arbitration, and we will go, if we have time, a little bit into that, there's risk for a company if they don't reply, if they don't respect human rights, that if they want to be protected in arbitration, they take the risk not to be heard, listened, or to have a decision which will not be the decision which will compensate the full rights that they would have lost if the state have expropriated them in a way or another. And in fact, I must say that very often there are some companies, they said, well, I am not on the stock market because I'm a national company. I don't need financing because I'm a national company and therefore I don't need finance from international financial institutions, I don't need the banks. Reputation, I don't care either. And in fact, there are some companies, they could say, well, for me, all that is okay, I understand, but there will be no sanctions. Or the sanctions will be very small. I think they make a big mistake. First, The first mistake is that if they need to partner one day, and you know in the oil and gas industry, you never stand alone. You always have to partner with other companies. And if you want to partner with a big company at the stock market, and if you have not applied those human rights, you'll never find a partner. So if you have a project which is in breach of human rights, I can tell you that nowadays, that company, even if they would be in a position where they would have no sanction, they would have a big one, not to identify a reliable and a good partner. And that company would even take the risk that if it goes to arbitration, it will go into problems. And if it has links in a way or another with England or with the United States, they would be under possible trial, which would put them in very big difficulty. So as you can see, it is clear that we speak of soft law. We speak of something which could be to some extent not always legally enforceable, but as a result, the role of a lawyer is to look after the clients when they know that whatever they do is going to be sanctioned. Is our job now only to look at what is going to be sanctioned by courts and arbitration? No. Our job now is also to go further than that, and in any case now, there are risks for companies and everybody to go to courts and have some problems if they don't comply with those principles. So as you can see, if I had to stop there, I could stop there, because I can tell you this is a clear message of where we are. So now you will say, okay, what is all about? I don't want to go back on Ruggies principles. There are clear obligations of the state to protect the human rights, but there are clear obligations for the companies to respect them. What does it mean? It means for me the AAA. It's a change of attitude. It's to anticipate, and it's to go above the law. I like to have, you will see, I have the AAAs, and then I will have the 6 Ps. I like to have clear message like that. So it is all to do with, I say to the oil company, as a lawyer, you must change your attitudes, you must anticipate, and you must go above the law. In fact, human rights is all about what? The impact of my project. It's not the risk for my company. It's a different way of thinking. It's the fact for a company to say, I'm not going to look at the risk for my company, I'm going to have a look into the risk for the people, the risk for the environment. So the way of thinking is different. So the way of doing is to be different. And this is why we have all those tools that Ruggies has put in place in order to help the company to change their mind, to change their attitudes, to think differently in the interest of the project for sure, but through the interest of the people and of the company. All that you anticipate that when we speak of accountability of companies, it is clear that companies with the stock market, with investors, with the banks, with the population, with local communities, with all those, they are accountable every day of their life. And it is now one of the highest risks that companies are taking is if they don't respect their accountability towards the respect of human rights. There will be lots of things to say as one of two. How much time I have left? Because it's again 5 minutes? Or? In fact, there will be many things have been said already on that tool. I want to simplify because I don't know you are all lawyers. You are all lawyers? Everybody's lawyer? No, some people are not lawyers. So I have respect. That's a principle of human rights, to have respect for everybody. So I have respect as well for non-lawyers. In fact, the Ruggie initiative and all the initiatives around that is to say how, for you, the company, how you should do. We're going to give you some tool. It's a box of tools, a tool for you to say, how am I going to be a good company? How am I going, if I go to court, if I go somewhere, I can demonstrate and prove that I behaved correctly. This is all to do with that. And that's the role of lawyers, is to say, be careful to this, be careful to that. We're going to give the good tools. And in the tools, it's very easy. You go where? In a soft law. You go to Ruggie principles, you go to the IFC standard, performance standard, you go into all that. We have all that. So now the only thing to do is to know how to use the tool. To be a good workman, to build a good house, you've got to be a good worker. And for us, is to be a good lawyer. So for this is not, I won't go into the details of human rights. I won't go into the details of what Madame la Présidente explained very well, that the company behavior is to say to itself, I must watch out of what I do, the impact of my project, and I must watch out as well what all the people working for me are going to do. Are they going to respect human rights? Are they going to behave in a way that I like and in a way which is my principles, that I want the best one in the world? This is very key. This is what we call the zone of influence. And the zone of influence of a big company, especially in oil and gas, does it go only to its partners, subcontractors, or does it go up to state companies? Or, Madame la Présidente, does it go to the state as well? And this is certainly some questions that I would wish to leave unanswered, and we shall still think of that. But this is certainly for lawyers, some issues that we've got to think of. In fact, for a company to summarize what they have to do is not only to be sure that they respect human rights, they've got to know that they respect human rights. It means to know is all those mechanisms, due diligence and other things, by which they can verify at all time that human rights are respected within the company, by the employees, by everybody, and to show, to know and to show. To show what? To communicate on their respect of human rights in a very transparent manner. So you can see as well that companies are very much accountable. They are very much responsible on their attitudes. They have to rethink everything. Instead of, for example, if there is an accident, something which is bad, they must communicate on it, they must show it, they must speak on it, they must maybe release it to the board of directors and make it very, very transparent. And this is where there's a big difference in what has been until today. The due diligence of companies is very key. In fact, a company must certainly have a very clear policy, but not only a policy, it must have what we call ongoing due diligence. It means that every day of the life of a company, the company must look into everything happening with the project and making sure that it doesn't jeopardize human rights. And if it does, it must take all the means in order to remediate to that breach of human rights. And it must participate to that mechanism that Madame la Présidente explained very well as the grievance mechanism which have been put in place by Ruggie. Now, I must try to conclude to some extent. I know, the French people, we can be very talkative, especially lawyers. In fact, to summarize, which is not, we cannot summarize, but especially before arbitration and litigation in terms of accountability, there had been some decisions already. I won't go into details with Argentina, and it's all about what we call fair and equitable treatment, and it is all about expectations of company. I would like to stay on this to have you clear message. In fact, an investor, when he goes in a country, he will be respected for his investment, and he will have some principles which will tell him you are allowed to expect some reasonable return on your investment. And there are some agreements, international agreements, which says that if the state where he has this project is breaching a tax regulation or something, which makes it that he won't have his expected return on investment, then he can go to arbitration. You get it? So it's simple. So the investor seems, I'm protected, which is good news. But now, what about the state, which has another expectation? Is the population have another expectation? Is the state have, you remember, Ruggie, the obligation to protect human rights? What about if a state has to take a decision by which the investor would not have his expected return on investment because the state had to take a decision to protect the human rights of its country? For example, the right of water. What's going to happen? The investors go to arbitration and will say, well, that project is costly for me because that state took a measure which is not good for me. But the arbitrators, do you think the arbitrator will say, oh, no, 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 indeed, the investors might be indemnified for everything? No. The arbitrators would have to think very carefully to balance, to make it a proportion, and to say, okay, where is it about? I need to balance expectations of population and the state and the public interest and with the protection of investors. Two treaties, face to face, of equal values for lawyers. Then we have today and nowadays those new principles of international and arbitration. I don't want to go into details. They are very interesting because we are on the way forward. Is now for the investors, they have to think that the arbitrator is going to think. And the arbitrator is going to say, well, I'm not going to sign a decision by which I'm going to allocate billions of dollars to investor if I know that in fact the state took a measure which indeed would harm the investor, but for the sake of public interest. Can you see how things are moving? Can you see how companies have now to anticipate how things will go with human rights? So their own behavior is absolutely key. Again, what I was saying is to anticipate all that, to have the right attitude, and not necessarily to stick only with the law, but to go above the law. And this is the new paradigm of where the old companies, mining companies, and lawyers have now to evaluate. Thank you. Merci beaucoup.
Thank you very much, Stéphane. I'm happy that you made it without your wife. Any questions, comments? Please.
Oh, well, I'd like to thank you for this interesting presentation, but just a couple of comments in the context of where we are in Russia. So you mentioned about the soft law and the sanctions, but when we talk about specific country, specific jurisdiction, we need to look for a specific specific mechanism and solutions. For example, a lot of people here in Russia would think that if a company, an oil and gas company, manages to use labor force at very low cost, it would mean efficiency and not bad reputation, and many of investors would even tend to invest more in that company, which makes situation different from other places. I personally have 10 years experience working as an in-house lawyer in oil and gas company, in metals and mining and energy. So, and I have never encountered such attitude as you described, unfortunately. And in terms of financing, same thing. Even if we talk about foreign banks, there was only one case with EBRD when there was the social and environment development plan was a condition to financing, but there was only one case in plenty. So I think what could help is if indeed businesses who have already undertaken to promote human rights and to respect would indeed will insist that their partners observe human rights, and indeed international banks and foreign banks would undertake to make this as a condition to financing and implementation of projects. Thank you.
Very good comments. Thank you.
Thank you. I think that's very interesting, and it's frankly speaking also my experience that still the majority of actually the businesses are looking for profits, and other concerns are second rated unless, and I think this is what Stéphane is pointing out, the reputation is regarded so high that you really get sanctions in whatever kind of soft or harder way when you do not behave properly. And probably this is in the West, people are much harder on the companies than in other parts of the world.
And Monsieur Stéphane preferred to be silent on the state policy, but I think that we should speak quite openly here. indeed, we've seen in Russia some turn from human rights to human duties, and some people even tend to think that human rights is an alien idea invented to invade Russia, and we've seen attack on the human rights organizations here in Russia. So indeed, the state's duty and state policy in respect of human rights, of course, would be a crucial thing for such purposes.
I think this is not only in Russia the place. I think also in Islamic countries and also in China, based on Confucianism, they have a different concept of human rights. But this goes very much into detail. Please.
It's quite clear a business case. Look, from the one side you have a profit, from the next side, different side, you have a human rights with all reputation issues, yeah, potential market issues. So you just have to calculate the things properly. And for Western countries, you'll see what it's more economically based to go with all regulations, to respect human rights and do the things properly. For some countries, it's quite cheaper to ruin human rights, getting more profit. And for businesses, quite a business case, plus, minus result.
I think there are countries, and I don't want to name them, where a certain number of deaths in mining is taken into consideration as kind of a necessity, so to speak, to do this business, and there is very little concern and very little effort to really avoid that. So it is actually, there are countries where human lives do not count a lot. And we have quite a variety, I think, of doing business in the mining industry worldwide, and I think there are huge discrepancies in the practice. Are there any more questions, comments from the floor? What does the European Court of Justice say? Oh, European Court of Human Rights. Oh, excuse me. Please.
I have nothing to do with the European Court for Human Rights. I'm a professor of the university here in St. Petersburg, and I'm listening to what is being said, and it seems to me that we speak different languages. Moreover, you probably do not understand very well what the situation is like in Russia. Particularly, I refer to the lack of understanding between those who are in the country and those who are outside of the country. Protection of human rights is stipulated by the constitution here in Russia. Physical and individuals, corporations or companies have no right at all to violate human rights. Moreover, we have an enormous number of companies which are taking upon themselves additional responsibilities. These are companies with corporate codes, conduct codes, and violation of human rights in association with low wage. That's something impossible here, because we have a minimum wage, and no company can pay less than the minimum wage. The company will be immediately held liable. Moreover, I do not quite understand what is being said about what? Let's go. The company that interferes, the transnational corporation that interferes into the affairs of the state, trying to replace the government in some way. How this is possible? I do not know at all. Moreover, let me remind you that we are discussing here social responsibility of corporations. It's not a new issue at all. 40, 50 years ago, the issue was raised of the responsibility of transnational corporations. That was the first that happened. In the year 2000, on the initiative of Kofi Annan, the global agreement was adopted, which is not legally binding for countries, and 10 principles were included into it, and all the corporations are expected to follow them. Human rights are among these principles, and actually everything there is very clearly described, point by point. Environmental protection, anti-corruption actions, and everything else that we can list. Though this has been known for quite a while, well, maybe something should be done within the country, or you might think that that's not important for a corporation, that there are international standards of conduct. Within every single state, there must be, you might think, special rules of conduct. Now, we have the continental system of law. Our system is not based on the principles of common law, where the approaches can be different. That's why I do not really understand well enough why we're saying that there is no interest to human rights in Russia. This is not so. Moreover, I do believe that corporations here do take upon themselves an enormous amount of responsibility, and legislators cannot do that for the corporations. No. The legislators can act against that, but if the corporations act against these principles, they're held liable.
I think just clarification, I think you're perfectly right. Social responsibility of corporations is not a new issue. We have that since 100 years. Sometimes it is part of our employment laws, and we have a huge body everywhere in the world where we have state laws which are spelling out social, environmental, anti-corruption obligations and rights. So I think this is everywhere in the world, one way or the other. But I think what Stefan is talking about, and also Lucy, was something on top of that, that you should have a worldwide policy, not dependent on what is regulated in this state or another state, or whether it is enforced in a state with a poor enforcement strategy, but that a multinational enterprises should follow the same standards more or less worldwide. I think this was the point. It was not what Stefan meant, that the corporations should be instead of the state taking this role, and this cannot be, but on top taking, so that the corporation has to take as their own responsibility to take care of certain subjects which are in their zone of influence. So this is it.
Could I just add to that? Yes, I'm speaking in Russia because that's where the conference is, but this is an international conference. And when I was thinking about these principles, I wasn't thinking about Russian corporations. I know nothing about Russia. I was thinking about English corporations, actually. And we also have all very strict regulations and so on. Doesn't mean to say that people keep them. And so it wasn't intended as a sort of a pointed remark about Russia at all, but about what goes on in the world.
Yeah. Well, for me, of course, I didn't speak of Russia. And by the way, that's my second time in Russia in my life. And I'm impressed by the beauty of the country. You know, the very close relationships between my country, France, and Russia. My stepfather is even a Russian person. He's Mr. Apraksin. So I feel very close to your country. My wife is even speaking Russian. So next time I'll come with her because... in fact, I was speaking of Africa, and I want to give you one example of an area where the state and the companies have to work very much together. That's land law. And I speak of Africa. You can't believe how often some companies, still the case, by the way, they want to do a project, and for this, they need to expropriate some villages, communities, people, ladies, kids, and everybody. And normally, this is the absolutely sovereignty of the state to expropriate. And if they want to be illegal, they have to expropriate against, fair indemnities and compensation. You can't believe how badly it is done so often in Africa. It's miserable. I would say it's miserable. I could give you some examples. Now, what is happening with those new principles, which is going above the law, it means that the company must apply the law, of course. But if the law is not sufficient in order to protect the local communities and the people, the wives and kids, what that soft law says, they say to the company, please behave in a responsible manner. If you are going to use that piece of land for getting billions of dollars of profits for your shareholders in France, in Russia, in the United States, and in Africa as well, then you've got to behave in a responsible manner, and you must make sure that the compensation, relocation of the population has been made in a fair manner. It means right money, right compensation, respect of villages, respect of mothers and the kids, respect of right to education, respect to access of water, and all those sort of things. I must say, Madame, with all respect, I love Africa. I'm not white, I'm not black, I'm red. I love Africa. For the past 25 years, I spent my life. I'm the lawyer for Africa. I love the continent. But it's not because you love something or someone that there are not sometimes little things that we think can be improved. And what is said to oil and gas companies and mining companies, they say, okay, you have no obligation pursuant to the law to pay more than 20 cents per hectare for expropriation. But the soft law says that you should pay $15 because the people after expropriation, they won't have any more subsidies to live, they won't have any more drinks, they won't have any more fields to make their food for the people. So the soft law says, above the law, we ask you to do better than that. And all what it is about is each time you can do better than the law, never against the law, never, ever. But if you can do better than the law, then please do it. This is all it is about. Merci, Madame, pour votre intervention.
Thank you very much. And thanks for this very lively discussion. That's great. Well, any last comment? I have seen one more finger or one more hand going up. I would take one more comment. Is there anything here? Okay.
I think that our colleague responded not to the speeches from the panelists, but to my intervention rather. Well, I would like to say that we all probably want that here in Russia and all over the world, human rights are respected, that human rights become the centerpiece of government policy, and they must be adhered to both by the government and corporations. This is number one. What needs to be done in order to advance in this direction? We may state that everything is fine. We may make a round of applause to ourselves and then sit on our hands and do nothing. Another approach would be to analyze the situation in a sober way, to acknowledge that there are problems and think how to resolve them. Of course, we live in one and the same country, and it cannot be that living in the same country. Well, of course, approaches may be different, visions may be different, but having worked for 10 years in various corporations, I can tell you that human rights are not on top of their agenda. What they have on top of their agenda is the bottom line and nothing else but the bottom line. And that is why I was saying that this situation must be changed, if not radically at once, but at least we should be moving in this direction. Yes, on paper, human rights are declared, they are protected and promoted, but let's see what happens in real life. There is this federation of independent trade unions that is trying to take a foothold in the Urals. The activists are being beaten. Criminal cases are started against them. The rights of women are not protected at all. I am not trying to draw a very grim picture, but let us just acknowledge that there is room for improvement, and this must be a priority of government policy. And, of course, it should be a priority for the legal community as well. Thank you.
Room for improvement, and also to answer to your comment, the world outside of Russia. I think Stefan and myself, we were both at the last IBA conference in Dublin, and what you see regularly at IBA conferences when you have corporate social responsibility panels, you see a lot of Africans in the audience and very few white-skinned people. And this is also, both of us, we attended actually a session, 165 Africans and 5 of us, so to speak, 5 white people. And this is actually something which tells a lot about the attitude of a lot of white business lawyers who are engaged in the IBA. They are in the M&A sessions, and Africa sits in the CSR session. And I think there is a huge room to be improved. So let me move on actually to our next speaker, who is equally interesting. And I don't want to cut off the discussion, but we can have more of it right away. Let me introduce Mikhail Popov. He's Vice President, Legal Affairs, and a member of the board of the National Aggregates Company. And he is getting us into the core of corporate governance, transparency, and shareholders' rights. So we are diving into the corporate core section. Thank you.
Уважаемые коллеги, на самом деле я благодарен за то, что дискуссия.
Thank you very much for steering this discussion in such a way that it smoothly transitioned into my presentation. I'm going to speak about profit and human rights, which are inseparable. I'll be talking about the rights of investors, of shareholders rather. But if you do business correctly, I think that profit and human rights should not be in contradiction to one another. Corporate responsibility, transparency, and the rights of shareholders, all three words included in the topic, are ways of ensuring the protection of interests of all the parties participating in economic activities. I think that all these parties are interested in profit, in the company making a certain profit and growth of capitalization of the company, because the government receives taxes and may protect human rights out of this monies. The society receives jobs and strong economy. Shareholders receive dividends, and the company fulfills its mission and earns a profit. The problems start when one of the parties in this process start to break the rules. There are rules, but whether they are good or bad, but when they are not adhered to, problems begin. Major risks related to appropriate corporate governance and transparency and abuse of shareholder rights, they occur when the business is not appropriately regulated, and then it arises from trivial avarice, trivial greed on the part of this or that participant in the process. What happens usually? Of course, it is clear that the company wants to show a better financial results. It starts doctoring its accounts. It happens in any jurisdiction. No matter how well developed the regulation is. It happens in Russia, it happens in the US, it happens in Italy, it happens elsewhere. You remember the Parmalat case. In many countries, this is so. This happens in large and small companies alike, because greed is everywhere. Unfortunately, in the Russian Federation, until quite recently, the regulation of corporate governance and corporate transparency was not receiving a lot of attention. Until now, we still have a number of gaps in several aspects of this sphere. The latest amendments to the Civil Code could make a very significant step forward in this area. Apart from that, legislators now are improving the law on corporations. Every 6 months we have the new set of amendments to this law, and we invest a lot of our hopes on the draft resolution by the Supreme Court of Arbitration on the compensation of damages by people who are part of a corporate entity, because abuses on the part of top managers of corporate entities are usually the most frequent type of infringement upon the rights of shareholders and all other employees of the company, because doctoring of reports is carried out by people who wouldn't like to get involved in that manipulative activities. The infringement upon rights of minority shareholders are also done by people who are unwilling to do so, but because of the lack of transparency of corporate governance, it is not possible to identify the problem at the time it emerges, and therefore such situations evolve. What is evolving is not the regulation in the field of corporate governance. The various aspects of responsibility and liability are developed. The criminal code was long ago augmented by 5 articles that introduced stricter sanctions for the violations of rights of shareholders and other parties related to companies. Those I'm talking about Article 185.4 and a number of other articles of the criminal code. All those articles are actively in use, and there are cases that are started according to those articles, and there are cases that are heard in court. Of course, there are appropriate sanctions in those articles that are commensurate to damages, and there are also some developments in terms of civil liability, but it is not it's not as successful, and case law is extremely diverse. In 2012, for example, the Federal Arbitration Court of the Moscow region decided to awarded 200,000 rubles of damages to a director of a company. He actually signed an agreement on voluntary medical insurance for 10 employees of his company, and he paid 200,000 for this voluntary medical insurance, trying to improve the situation of his employees. But this was considered by court to be damages sustained by his company.
In 2012, the District Court of the Northeastern District of Moscow decided that in a similar situation, when they paid to security companies, although they did have a lot of janitors and stuff, the court decided against it, although the amounts in question were more significant. And actually, when we talk about such examples, when we talk about the damages that are being awarded or to be paid by shareholders or by the management, they are not so numerous, but there are a lot of cases to the contrary. And sometimes there is no logical connection between the judicial decision and the facts of the case. Therefore, we do hope that we will get the remedies. Apart from that, there are a number of pressing issues that would allow us to improve corporate governance and increase the transparency. I think some of these measures include the following. All of the Russian companies, the Russian federal law on accounting says that all of the Russian companies should adhere to the Russian accounting standards. And I think all of the Russian companies and their shareholders that do not look at these accounting standards, because the accounting standards do not really tell much about the standards of an organization. They look at the corporate reporting, and according to that, nobody is responsible, nobody could be held liable. Therefore, the shareholders look at reporting that does not really give many facts, the Russian accounting standard. Furthermore, the situation would have been quite funny if it wasn't so expensive for the Russian companies. The Russian companies have a responsibility to disclose the information about its shareholders if they hold more than 5% of the stake. They have to disclose the information on the members of the collegial governing board, and so on. And what is interesting is that none of these entities have a liability to disclose such information to the company. I think each failure to disclose costs around $30,000 in administrative penalties. And I'm not even speaking about the fact that the corporate law and the anti-monopoly law provide completely different definitions of the responsibility or of the parties thereto. And again, when I was talking about the non-disclosure of information, this is also true for the number of shareholders. For instance, I can give you a very recent example. When, in order to ensure the compliance, some employees of these companies would send funds abroad, and therefore all of the business partners were asked to provide the data for the beneficiaries of such transfers, and therefore many people in the company found themselves in a situation where they couldn't do anything because they didn't know their end beneficiaries. They knew that there were funds or that there were some offshore organizations, but they didn't know who exactly was the beneficiary. Therefore, to conclude my speech, I would like to repeat once again that successful actions, successful corporate actions, as well as profits, corporate profits, the rights of its shareholders, is an economic basis that gives the government a possibility to finance the insurance of rights of all other individuals. And here in Russia, we have to work on improving this issue. That's all from me.
Thank you very much, Mikhail. I wonder how things will change when Russia is exceeding the OECD, because the OECD has guidelines for multinational enterprises, has guidelines for corporate governance standards, has guidelines on a lot of things you were just touching on, and I wonder how this is going to develop.
Well, as far as OECD is concerned as an organization, then I can say yes, there are codes in place, and furthermore, Russia, within the framework of studying a possibility for OECD accession. But to tell you the truth, we're really far away from this. We're just studying the possibility, but we are studying the possibility of implementing these codes. But I would like to say one more time, of course it would be extremely beneficial, but Russian regulation is very far from these standards as of now, and until these standards are implemented, I think we have to do a lot of work and apply a lot of effort, but of course it would be great also to increase the transparency of the Russian company when they attract funding or investment.
Yeah, there is always room to improve. So thanks for that. Any questions from the floor? Comments?
I have a question.
Yeah, please. Excuse me.
I have a question. Today, the United States and Europe now are adopting some regulation in the line of the EITI on transparency. Is Russia, like for the OECD, considering to discuss such type of regulation?
Actually, I can't speak for the Russian government, but discussion about that hadn't stopped. It was started like 10, 15 years ago. It hadn't stopped because generally everybody is interested in this transparency, including shareholders, management of the companies, state, and all around.
I think EITI is Extractive Industries Transparency Initiative. So, and it's actually for the companies to be complied with rather than for the government. I think you mentioned one thing, if I understood that correctly, Mikhail, and this is a discussion we are having also in Germany, and this is to what extent are you allowed to do anything on top of the law because you might infringe shareholders' rights, meaning in German it's Untreue. This is a criminal offense if you actually treat the company funds improperly. And there is a discussion to what extent if you do any kind of pro bono things or your charity things, you take away funds for good purposes, but when it's not approved by the shareholder actually community, then the question is this a criminal offense because you're dealing with the funds in a different way than actually only for the main purpose of the company, that's profit making. Did I understand that correctly?
Yes. First of all, this action could be a criminal offense by even 2 articles of Russian Criminal Code, depending if the person had some interest in that or not. It could be присвоение или растрата, или причинение.
It could be embezzlement or damage.
Quite broad and cover all those situations. Okay. Российское законодательство вполне покрывает.
So the Russian legislation is very broad and it covers all of these issues, and I can say that we have sufficient norms and regulation that would allow us to bring somebody or to hold somebody criminally responsible, somebody who overstepped their official obligation, and we have a differentiation whether a person was personally interested in or not. We have differentiation about the size of the damages. Another issue is that it happens quite often that these regulations are sometimes used to settle commercial disputes and not for their direct purposes. Only sometimes even the charity, if it's not allowed, it will be prosecuted criminally.
Thank you very much. Are there any comments or questions for Mikhail? No. In this case, I would like to break for the coffee break. Let's do a brief coffee break of 10 minutes, and please come all back. We have 3 more interesting speakers. Thank you for the moment, and thank you very much for this very lively discussion. It was a pleasure. Well, thank you very much for coming back on this Friday afternoon, and thanks for joining us again. I hope that we will continue to have a very lively discussion. And the first speaker now after the coffee break is Tatiana Gorovaya. I hope I've pronounced that right. Thanks. She's the Legal and External Affairs Manager of Nissan Corporation. And we will get now from a corporate side, Nissan's corporate social responsibility strategy. So we will dive right into the details and the practical view of a corporation. Tatiana, floor is yours.
Yes, thank you. Сразу хочу сказать, презентацию подготовила на
I
английском.
would like to say right away my presentation in English, but since most of the audience are in Russian, I'll speak Russian if I may, just to make things more convenient for everybody. So if there is something that is unclear in my presentation, I will come up with explanations. Now, thank you for being back after coffee. And I'll try to make my presentation in such a way that no one feels sorry that they are back. My colleagues spoke about corporate responsibility and human rights, and I would like to speak about the Nissan company, where I have been working for 7 years as one of the companies that are most successful in introducing the notion of corporate social responsibility. And I will explain to those who are not well familiar with the notion what it actually is. And I will talk about the Nissan vision in this context. Right. So, corporate social responsibility. Of course, any company works for profit. Big corporations, and not just big corporations, other enterprises also do think of the impact they have on the society. And Nissan is not an exception from this rule. And at the same time, there are certain differences between us and other companies, because the social responsibility of Nissan might be a different notion for our company, because the main message that we are implementing in the process of the work is the implementation of sustainable development, not of the company as such, but sustainable, long-term, deep, profound understanding of how a company can influence the society, the spheres of life in the society that are most important, social, economic, environmental rather. And so it's sustainable influence that we talk about. For the social corporate responsibility to be properly structurized and implemented, we developed a program which is entitled Blue Citizenship. The program is first of all intended as a program that is reflecting our relations and develops our relations with the stakeholders. And stakeholders are dealers, suppliers, employees of the company, and owners of the company, and customers, of course, who buy cars. This program covers corporate policies and internal controls, economic development, environment, safety, quality, and employees, sustainable relations with dealers and employers, and philanthropy. Corporate social responsibility is not just philanthropy, but it's a global approach to all these fields I have described and to the influence the company can have on these. So the first of these is the corporate governance and internal control. Well, definitely, it is necessary to introduce in the company the compliance policy. The compliance policy described extensively at the forum. Everybody understands how these policies are becoming more and more important nowadays, and information disclosure is very important in view of transparency. The company understands how important it is to inform the suppliers, the customers, the employees with information that reflects the goals and purposes of the company, the tasks it set for itself, the policy that shows progress, success of the company, so that everyone who has anything at all to do with the company understands their role, or rather his or her role, and their goals associated with the companies, if we take dealers and suppliers, of course. And risk management is another important sphere. This helps the company regulate risks and prevent risks that might emerge in the process of operations. So these are three very important issues that company works upon, and internal control is a part of this particular aspect of corporate governance and internal control. Then environment. Definitely, we all heard, we all know, and probably follow the progress achieved in the area of environmental protection and measures that are taken by the business community for the protection of environment. Of course, Nissan, as a manufacturer of cars, and potentially is one of the most interested parties in in environmental protection. So we pay a lot of attention to this issue, and we have developed a so-called green program that includes all the major measures taken by the company with the purpose of protecting environment in different fields. Technologies, first of all. You might know, and here in the presentation you can see Leaf, the first electric-powered vehicle in mass production. And the Nissan company at present pays special attention to the manufacturing of cars and technologies that enable the company to reduce the negative impact on the environment. One of the priorities of the company at present is complete transfer of the functions and operations necessary for the car manufacturing to such a type of rails that the manufacturing does not have any negative environmental impact. Apart from the technologies that are developed within the company, of course, Nissan also thinks about the development of culture, corporate culture, and it's necessary to make sure that the employees, the stakeholders, dealers, customers, suppliers, understand what all this is about. It's necessary to form their motivation in such a way that they provide environmental protection. Now, safety, you are all drivers, I suppose, and you all understand how safety is important and why it is so important. Because when you buy a car, then, well, most probably, first of all, you look at the automobile, at its exterior, and trying to understand how comfortable it is for you, and you pay attention to the way it looks. But safety is among the most important issues for the customers as well. Nissan went even further, and apart from the understanding that we attribute to safety, Nissan also thinks carefully about the culture of driving, safe driving, develops training programs, training in safe driving, and Nissan cooperates in that with different universities, institutes, the entities, the schools that together with Nissan work on the training programs. educating people how to behave in the streets, how to react and interact. They teach drivers and pedestrians, and all this is done to ensure safety. Safety is priority number one in driving. Then quality. This field for car manufacturers is most important, since product quality is immediately related to the profits we get selling our cars. But under quality, we understand not only the product quality, but also the services quality, the quality of interaction with the dealers, training of the dealers, training of our personnel, of our employees. We teach them how to behave within the framework of standards, how to improve the quality of their work and change the approaches. And we also think a lot about the quality of management. Later, I'll say a few words about the quality of management, but at the moment, just to mention, improvement of the quality of management is not just a slogan for us, but actually annually we carry out employees surveys, and all the employees of the company, no matter where, in Japan, in Mexico, in Russia, in the United States, wherever they are, answer the same set of questions. And thus we get quite a clear-cut picture of the satisfaction of our employees with management. So every single person can express negative or positive opinion concerning the management, the administration of the company, understanding of the brand of the company, conditions of the work at the company, and the role they play within the company. Then the economic contribution. Definitely, any company, first of all, is aimed at making profit. But in this context, we rather talk about the sustainability of the company and about the image and reputation of the company. The company has in public opinion. And the more sustainable, the more successful is the company, the more foreseeable is approach of the management, and the high is the level of respect to the company among the partners. Information disclosure is another important condition of company success. And it's very important to establish trust and confidence. And it's also very important for good communication between the company and its partners and its stakeholders, employees, suppliers, customers, and dealers, other players as well. Now, employees. A few minutes ago, we had a discussion about the priorities of the companies. Should the first priority be profit or protection of human rights? I think there must be a proper balance, because, of course, the company, first of all, is established to make profit, which is not a secret at all. But those people who work in the company should know, should understand what the purpose of the company is, and should feel comfortable working at the company. And we expect them to be proud of the company that thinks of their needs and of their wishes, and the company that definitely considers business needs. Allow me to mention just a few things here, which we believe to be very important. First of all, it's respect of diversity. Respect of diversity is very important, and at Nissan, for Nissan, rather, it is most important. The examples that I have show that the approach is quite democratic, that a lot of attention is drawn to the development of the policies, and I am a member of the Ethics Commission. Any employee can come to us if he or she thinks that their rights are violated, whether by colleagues or anybody else in the company. And the company, on the basis of its ethics standards, which is our own legislation, makes a decision in every particular case. And so for us, it's extremely important. And then we also take care of the career development of our staff. And if a person indeed wants to develop, wants to make a career, wants to get training and education, possibly choose a different field of work in the company, it is also quite possible. Since for the Russian market at the moment, it's probably not the typical of the Russian market, but my boss, who is from Japan, who worked in the company for about 40 years, taking different positions in very different spheres, and finally he was director of the plant in St. Petersburg. Prior to that, he had been responsible for human resource at the company, then still earlier in the quality department, quality assurance department. So he's a person with an enormous amount of knowledge, a great wish to work and share his experience and knowledge with the company. And the company definitely supports that. The company tries to satisfy the needs of the employees and create plans for career development, and they respect a wish to develop, a wish to make career in this field. Then, as I said, management quality. In the company, a lot of attention is paid to internal communication. Any employee, whether he is in manufacturing or in finance department or elsewhere, has access to information. Has access to information on the success of the company, plans of the company, new developments, latest statements of the management. At any moment, through the system of internal communication, he or she can ask for this information. This is open information, and moreover, we have meetings on a regular basis at which we explain to the employees a lot of things and answer their questions. I wonder if we can compare this situation with Putin's 3-hour sort of a press conference at which he asked questions of numerous people. No, we have, to a certain extent, similar meetings with the company administration at which anyone can ask questions about his or her future in the company and role in the company, which definitely makes our employees feel respected and needed in the company. Realizing that their opinion is very much needed. Labor safety is a top priority for the company, without which it's impossible to build relations on the basis of respect and confidence. Nissan also does a lot to establish proper communication with dealers and suppliers. We explain to them what our ethics standards and conduct standards are. And three most important pillars of this relationship is Transparency. Transparency is very important for long-term relations with the suppliers and with the dealers and with customers. And then philanthropy. No, many in the past understood philanthropy as social responsibility, but for us philanthropy is humanitarian support. An example of that at the time of tsunami in Japan, and you probably remember what happened not so long ago. Nissan not only provided financial help, but all the employees of the company had a chance to take part in this project, and they were collecting money, donating money, transferring money to the accounts, and they knew that the money was on the accounts and how the money was spent. The contribution into the environmental protection through different training programs and different actions that reduce the negative impact on the environment, and educational programs and training courses for the employees. We work with institutes, with different universities. And
so one more time, our Blue Citizenship program that I've been talking about here today. This is a very long-term, far-reaching program. And the aim of this program is the contribution of the company into the structured approach to the impact that we have on the environment, on the society, as well as different impacts that we have on the economy, as well as working with our stakeholders, dealers, and the suppliers. So maybe if somebody is interested, I can tell a little bit about Nissan in Russian and the social responsibility that we delivered in Russia, because of course I can talk at length what Nissan does globally and about the global responsibility of Nissan, but I would like to give a couple of examples which might seem interesting. In 2008, we built a production plant. Back at the time, the capacity was 50,000 cars per year. So now company assumed even broader responsibility before the Russian government to increase the production capacity. And you probably know from mass media that we have an alliance with Renault and now with Autovaz, a Russian car manufacturer. So what we do together with our partners, we help and we work in the Russian town of Tolyatti. We work on establishing new production lines in Tolyatti. So localization of production is one of the directions for Nissan. It's one of the priority business directions for Nissan. So going back to the social responsibility of Nissan, here we are talking about the development of local sourcing opportunities in Russia, because as you know, and it's not a secret, that most of the companies, most of the production companies who come to the local markets, they use business processes which have already been established. For instance, we used to receive spare parts from Japan and China, which is not so great for local manufacturers, because local manufacturers are of course extremely interested in getting new orders or signing new supply contracts. That's why for Nissan it is a priority to look for suppliers here. And it is not just looking for the suppliers, but when we see that a supplier, a local supplier, has capabilities to establish long-term cooperation and has capabilities for long-term development, then we help Russian companies. We educate them in terms of standards. We train their employees so they are capable of becoming our partners. And we do the same thing. We explain our standards and we educate them in our corporate social responsibility standards. So as you see, our activities, our actions are very broad and extremely far-reaching and go well beyond Nissan. As I've already said, right now we are expanding our capacity, we are expanding our production facility, we are expanding the volume of cars produced per year. What else can I say about corporate social responsibility? Well, of course, the government and the regions where Nissan is localized are all interested in tax revenues, and what it allows me to say, it gives another education about the transparency in the company. We can say that we pay all of the taxes. We do not use any gray, black, or whatever color you might designate to them schemes. Then again, we are creating new jobs. We're about to reach 4,000 jobs, so we're developing local regions. It's a significant impact on regional development, and of course providing the training for the people. And here we're in close partnership with local universities, colleges, and other educational establishments. We are extremely interested in training and development of students as well as new hires in order to bring their qualification, knowledge, and competence to the desired level. As well as, of course, increasing their awareness of legal issues and the principles of corporate and social responsibility. And then again, philanthropy, which I also talked about. We provide help to a hospice, we provide help to an orphanage. And we also, as I've already said, work with colleges, institutes, and universities in facilitating their training programs and providing additional training to the students who are later hired by Nissan. So I think that concludes my presentation for today. I'm not sure how brief I managed to be, but I tried to show you the main directions, the main corporate directions for social responsibility. I tried to explain what social responsibility is for Nissan, and I hope that it was informative. Thank you very much.
Thank you very much. Tatiana, this was extremely informative because you touched on all the various subjects and you showed how broad the subject of corporate responsibility is, touching on product design, touching on the manufacturing process, touching on all the soft factors concerning employees and governance, and in the end also philanthropy, reaching out to the society and giving something back. So thank you very much for this kind of example of Nissan, but it's an example for the whole range of CSR issues, also crossing over in the sustainability discussion. This is closely linked. Are there any comments, any questions? Yes, please.
Vladislav from Mospro company. Well, I wanted, if it's possible, I wanted to ask you, what there are different social projects, say, if you talk about music or musical arts, they also require support. They might be non-commercial, non-profits, if we're talking about a rock band, a pop band, or a symphony. And does your company have a right to support such a musical project, whether it's a startup project or a well-known one? So how do you run corporate expertise? How do you make the decision where to allocate your funds or where to allocate your support? If you talk about music, do you consider professional unions? Do you consider educational establishments? Do you look at authority? How do you do that? Yes, of course, we do provide support. And in each specific case, we decided on a case-by-case basis, because Nissan, first of all, looks at the social impact and weighs whether it is important and whether the support is needed, because, you know, support is not only funding, but support, as I've already mentioned, could be provided through joint cooperation, like for the universities or colleges, because, as you know, universities or colleges, they're not looking for funding, they're not looking for an injection of funds, they're looking for orders that Nissan could place, say, orders for the training of students, or one of the cases that we had recently, Nissan sent a number of students to our production facilities in Japan and in the UK, where they had a chance to familiarize themselves with our production process, with our quality management system and quality control system. And by doing so, we support them educationally. So the support that we provide, it could be extremely different. And again, we decided on a case-by-case basis. Okay, I'll ask you a question privately after the session.
CSR, and this is something which is sailing at a little bit in the shadow, is all these non-profit organizations, or a lot of them, have a very lousy governance. And I think it would be very helpful if the big enterprises, before handing out monies and large sums of money, would probably include in their supply chain, so to speak, on the other hand, also non-profit organizations, in order to check whom they are giving money and whether this is an organization spending the money in an efficient and transparent way. That's just a short comment from my side. We have to switch the order of the speakers, because I understand that Sergei Kiselev has to catch a train or a plane. He will come now next. He is the Vice President for Corporate Affairs and Communications of JTI Corporation, and he will speak, and this is directly connected to where we ended with Tatjana. He will speak about corporate philanthropy and government regulations and the new restrictions for the tobacco industry. Sergei, please.
Thank you very much, Madam Chair, and thanks for prioritizing me. I think my presentation will follow naturally that of Nissan. I was not planning to discuss tobacco regulation limitations in particular, although I will touch on them very briefly, but I wanted to talk about the culture and practices of corporate philanthropy in Russia in the light of the evolving regulation. Again, like my Nissan colleague, I was advised to prepare my presentation in English, which I did. But considering that the majority of the audience are Russian speakers, I will try to do this in Russian, even though I was not planning this. Следующий слайд.
Next slide, please. So I'm a representative of Japan Tobacco International, or JTI. Our company is the leading manufacturer of tobacco products, and we are an international subsidiary of Japan Tobacco with the headquarters in Tokyo. Well, the headquarters of Japan Tobacco is in Kyoto, and our headquarters is in Geneva. The company operates worldwide, and we have around 25,000 employees. We have 90 offices in different countries all over the world. Our products are sold in 120 countries. We have people coming from 106 ethnicities, speaking 40 languages. And overall, we have 25 production facilities all over the world, as well as 6 R&D centers. As far as Russia is, can we go back? Yeah. As far as Russia is concerned, I can say that here we have around 6,000 employees. We have 4 production facilities, the largest of which is located here in St. Petersburg. This is the largest factory that our company owns worldwide. And we can say that in the years of our operation here, we've invested more than $1 billion into the Russian economy. Next slide, please. So if I talk about philanthropy that's of our company, this is part of our global philosophy. So philanthropy is carried out in more than 40 countries. So here we chose two areas where to apply our philanthropic efforts. First of all, providing support to people and providing support to arts. So our work in the field of corporate philanthropy is absolutely voluntary, and it is completely unrelated to our commercial or business activities. Our corporate activities in the field of philanthropy is motivated by our sincere wish to make the situation better and to make an impact on increasing the well-being of the societies where we work. We never use it in order to market our products. And that has always been a part of our philosophy, which also reflects our will to be a part of something good. As you know, today there are a number of theories why corporations decide to go into philanthropy, and some of the corporations see this as an opportunity to support and develop their core business through sponsorship. Other corporations or other companies use the concept of corporate social responsibility, and they see their charity work as a way to decrease the negative impact of the business, of their core business. Well, to talk about our company, what we want to do, we want to use our philanthropy in order to have an impact in the countries or in the societies that we work in, so that we commit to our obligations as taxpayers and as dutiful employers. Therefore, our approach to corporate philanthropy is different from the previous two concepts that I've described just then. Corporate philanthropy for us is a way of self-identification, and this self-identification is something that we actively promote among our employees. Therefore, our commitment to giving back more than just the taxes and the wages is supported by corporate policy, where a certain percentage of our operational profits in the countries where we operate is mandatorily allocated to philanthropic projects. Next slide. So while doing our charity work, what we decided to do, we decided to impose voluntary limitations upon ourselves. So we do not work in healthcare, we do not work with children, and we do not work with sports. This is a conscious choice that we made because we would like to avoid any sorts of accusations that we're using double standards that might arise. So our budgets allocated to philanthropy in each of the countries where we worked we can say that these budgets are distributed almost equally between the support provided to the people and support provided to the arts. So if, while talking about our social projects, I can say that we focused on those areas which, in our opinion, are less popular among other corporate donors, such as support of the poor, support given to the elderly, and support given to war veterans. As you know, the elderly, to give you a particular example, they're not high on top of the agenda for many corporations that are working in Russia. Therefore, here we are filling a vacuum or bridging a gap that exists in this area. So if we talk about our social projects in Russia, supporting the people, as I've already said, here we mainly allocate support to war veterans, World War veterans, as well as support to the disabled and the elderly. Our geographic focus is in Moscow, St. Petersburg, Leningrad, and Lipetsk regions, and this is not an accidental choice. This is where our production facilities are located, and therefore we would like to reach synergy, because we have our employees there, and our employees can participate in these charity projects. So the support that we give is given under long-term programs, when we provide gifts for holidays, when we organize charity concerts for the disabled or for the war veterans. We are very active in establishing computer education for the elderly. We train them in using the internet, and therefore it eases the loneliness that is unfortunately very often encountered by the elderly in this country. As far as the war veterans are concerned, here we decided to focus on working with the blind. 2 years ago, we published a map of St. Petersburg. We published it in Braille for the blind, and this map has all of the public transportation routes, and all of the social institutions are also marked on the map, so that the blind feel freer to move around the city. And we've also been working on providing guiding dogs for the blind. After the Krimsk tragedy, we also responded by providing relief. We cooperated with a British NGO who provides tents as well as relief workers' equipment, and as a rule, these tents are usually used by the local people who lost their housing until such time when the housing is restored. We also provide support to the adults, not to children. And here
we mostly support economic and programs in different universities, including the State University in St. Petersburg and the European University. Now, as for the support of arts, now, here we work along several lines. We support traditional Russian art, and the traditional art is also supported by us in other countries. We have long-term and large-scale programs of cooperation with the Mariinsky Theatre and Bolshoi Theatre, with the Hermitage, with the Pushkin Fine Arts Museum, and with the Chekhov Drama Theatre in Moscow. A few years ago, we decided to develop a program aimed at the modern arts support, and for 2 years by now we have been working with the Moscow Multimedia Museum and with the State Center of Contemporary Art. and we render help to the young artists of Russia. Our roots are Japanese, of course, and we support Japanese art, and not just art, but economic achievements of Japan, promotion of Taizen principles in Russia, and that's in great demand, and the Russian audience is very much interested in that. The focus of our work is on the long-term partnerships. Partnerships that would provide a predictable and long-term implementation of projects, thus assuring that our partners that the assistance they get from us is not something that just happened, but is going to be long-term assistance. JTI is a member of the board of the major cultural institutions in Russia, the Hermitage Museum and the Mariinsky Theatre, among them. A few words about the mechanics of the selection of projects. There was a question about this issue in the process of the discussion we had earlier. There are two mechanisms, the internal and the external mechanisms. They are very much needed for the evaluation of the projects before they make the final decision on whether to include them into our portfolio or long-term philanthropy or not. External examination is first of all carried out in the close contact with the local authorities, because if the projects we suggest are irrelevant according to the opinion of the local authorities, according to the local charity organizations and philanthropic organizations, then that means they're not really needed. So we discuss these potential projects with the authorities, with the professional entities, with NGOs, and we are always looking for projects which would bring benefit to the society in the long-term perspective. Within the company, we also carry out detailed analysis of the projects as they emerge. First of all, we focus on the quality and assessment of the quality of projects, on their diversity, and on the long-term impact of the project results. We have corporate standards which we apply as any other international cooperation. We carry out the quality analysis, and this is done by our staff members. There is a group of these professionals who come from different organizations, cultural, from NGOs that operate in the field of charity. And so these are real professionals in the field. And so we also involve consultants who have deep knowledge and deep experience in the charity business. And then, of course, assessment of risk is extremely important. And when assessing risk, we first of all look for the NGO support, the ones that are professionally involved in charity work. So we do not work with individuals. We work with NGOs with a long-term history of carrying out philanthropic projects, the NGOs that work in a transparent way and provide the necessary reports. And finally, a few words about the implementation. We are not carrying out these projects entirely by ourselves. We act through partnerships. Partnership with transparent and well-respected NGOs, funds and foundations. Next. A few words about the constraints which the regulatory environment in Russia sets upon the philanthropic work. We do think that these constraints do exist. Some of these are associated with Russian traditions. Others proceed from the legislation. The tradition of transparency, which is so customary for the international companies, including the control mechanisms, external control over the work of this or that company through the boards of trustees. Now, these traditions in Russia are not well enough developed in Russia as compared to Western Europe and the United States of America. Then it seems that traditions of the support provided by individuals and corporations, of the initiatives that are not related with profit and are not orientated at profit. The statistics shows that a very small amount of Russian people make donations at present. And recently, the anti-tobacco law adopted in our country. Now, this is something that really touches upon the situation of our company and position it. It comes into force next month, but cultural events will not be any longer supported by us if we are using our logo. But we can get engaged in charity and philanthropy without using the logo. Our partners and those who get our assistance do not understand where the logic here is, why these constraints are being applied to us. But we will continue our philanthropic work in Russia in compliance with this new requirement. Moreover, we can say that we have plans of further expansion of our philanthropic work in spite of these changes. At the same time, we believe that lately there appear positive signals. The regulatory situation, the regulatory environment is changing. Some of the NGOs, some of the professional associations of these NGOs in Russia are drafting principles and methods of reporting that are acceptable for such companies as international companies, where it's a norm. These reporting principles are a norm of their work. And the Duma now is discussing the draft law on philanthropy, and we do believe that this new law will definitely provide a clear-cut system of relationship between the sponsors and the donors. And thus, the practice of donating money by the individuals in Russia is spreading. And the final slide, and I'm coming to the end of my presentation, some conclusions. I would like to say that our approach is based on long-term initiatives which are relevant for the society. We keep assessing and evaluating the feasibility and the potential strength of the old projects and the new projects, always focusing on their sustainability, on the establishment of long-term partnerships, and the value of these for the society, for the local communities. Our focus also is on transparency and reporting and accountability. We definitely carry out this work in compliance, in complete compliance with Russian legislation. Thank you very much. Your questions, please.
That I had to cut a little because we have one more presentation. So are there
questions after that? Or
Pardon?
I can raise a question. Or after
Sure. Yeah, of course.
По-русски, если позволите.
Oleg Rumyantsov and Partners. Now, when we were at the events at the Marinka, all those who were invited, starting with the plenary session and up to the wonderful performances on the old and the new stage, I noticed a leaflet that was given together with the tickets. The sponsors of the Mariinsky Theatre were listed there. I always have a look at this list. When I was vice president of Shell, and at the request of Vladimir Vasilyev then, I did as much as I could for Shell to become one of the sponsors of the Mariinsky, so I always noticed these lists. And as an institutionalist, I really cannot understand the ban on the sponsorship in art based on the sectoral approach. I think it is a violation of the constitutional principle of the equality of the subjects of entrepreneurial activity if they do not violate the law when carrying out this activity. So I wonder if the sector is planning to insist on any amendments of the recently approved and adopted tobacco law. Thank you for your question. It's difficult to talk for the sector as such because JTI is a unique company as compared to many other players in this market, in our sector. Our competitors are not involved in what we are doing, so I'm not sure whether they're ready and willing to support us in that or not. But I have already mentioned the law on philanthropy, the draft law discussed by the Duma at present, and which is being promoted by some of the well-known representatives of the Duma, who themselves come from the artistic community. And this draft law makes it possible for the sponsors to the donors to talk to the those who subsidize them and establish a certain level of relationship between them. So we just hope that there is a proper discussion, that the tension associated with the adoption of the anti-tobacco law somehow quiets down, and the deputies listen to what we need to say and what the philanthropists need to say. As I said, this is not the main thing for us. It's nice to see the logo of our company, indeed, because it is the recognition of what the company is doing. But if the society collectively reasons that this should not happen, then we, as law-abiding corporation, as a law-abiding corporation, will just follow the law.
Thank you very much, Sergei. Let's come to our last speaker, Andrei Bushev. He is Associate Professor at St. Petersburg State University and General Counsel for Russia and CIS at International Paper. And Andrei, he will take us back a little bit again into the more fundamental issues about state responsibility for private actors' behaviors. Does corporate accountability imply public function in a human rights protection? Andrei, the floor is yours.
Okay, thank you. Let me, for the sake of and not discriminating anyone, speak in English. I'm sure that most of the Russian audience speak, if not all, speak English, at least at my level, and you can understand me being not native speaker. Okay, agreed? Thank you. It's really a pleasure and a privilege to have a chance to share with you my thoughts and ideas which we bring to and follow in my company. And I'm having sort of two heads. One head, which belongs to the university, asks me to speak about theory, and I will a little bit. And my second head, which belongs to the business, tells me, please speak about best practices, about sharing best practices. So my presentation will be divided into two parts. In the meantime, I understand that I'm facing a challenge, and the challenge is to respect your right to private life, because we are short of time and we are approaching the end of this nice session. So I'll try to be short. Thank you. So we lawyers speak about notions. We need to define what are the criteria. We need to understand why
how one notion is different from the other one. I remember more than 10 years ago, after Enron case, the world was talking about corporate governance. For me as a lawyer, the question was, what is corporate governance? How it's different from corporate law? Whether it's a sign, whether it's art, whether it's sort of combined theory. And then the answer for myself to me was, it's more about processes. And it's more about what we already have in Russian and had in Russian law, but just with different name. The similar comes to the human rights. The Russian constitution set out human rights long before, in the constitution, long before the European Convention came into force in Russia in May 1998. In other words, we all have that. Maybe not everything, but most of that stuff. Now the question is how to define notion which is commonly used abroad with those which we use here in Russia. So what is corporate social accountability to me? This is, as Stefan rightly pointed out, and thank you, to me it's more about behavior, it's more about attitude, it's more about spirit. What is business ethic? How it's relevant to corporate social accountability? I think they are very, very close each to other, and they're both about attitude. Where is in this puzzle the place for human rights? How they match with corporate social accountability? To me, human rights in that activity by a corporation is about focusing, about priorities. In other words, when the company makes or has its business in certain way, with certain attitude, it must focus to human rights. Not only, but it must be one of the priorities of the company's activities. I'll later come back and try to explain why. So now let's talk also a little bit more about the theory. It's well known that human rights, they are applicable directly or indirectly to most areas of human activities. Whatever we do can be linked in this way or in other way to human rights. The definition is very broad. And Professor Galenskaya today very rightly pointed out that indeed, when complying with Russian laws, we respect in that way human rights. So it's very broad definition. In the meantime, it's the public authority's duty under the international law and domestic law in Russia, its constitution, to obey, to comply, to provide the mechanism for human rights. The third statement, state may assign, attribute its function to private actors, to corporations. And then the question poses, who in that case is responsible? The state, who under international law and under domestic law is responsible for protection of human rights, or the company, the private actor becomes responsible and liable instead of the state. And there are different theories around that. The positive obligation of the state, or in some writings it's called due diligence obligation of the state, is about creating certain areas, certain legal infrastructure. It's not only about having right laws, having law in the books. It's more about mechanism of implying the law. The law must not be and may not be illusory. It should be effective and active. And negative obligation is for the state is not to interfere into the private relationships. What if the company with 100% of state shareholding holds the plant, and the plant explodes, and as a result, the residing premises are destroyed? Who will be responsible? Who will be liable? The corporation or the state? And if the state, at what ground? On the positive or on the negative concept. So then there is an issue of criteria for defining controlled private actor, corporation, and not controlled. Fifthly, if the corporation is expected, and we've heard today in the beginning the notion of duty, social corporate accountability as duty, as sort of expected obligation of the company, shall such company be compensated for performance of their public duty? And remember, the duty to facilitate the human rights belongs to the state. Now, corporate social accountability. I agree with Stefan and with other speakers that it's more about culture, it's above the law. It's not only complying with law, it's something in addition. And we've heard today a very great presentation of our colleagues, how big corporations are dealing with that, what they do in addition to what is required by the law. To sum up, corporate social accountability in the context of the human rights is a way of doing business to ensure the concept of protect, respect, and remedy is applicable. Is it a nice thing to do, or it is absolutely necessary? From the first glance, why we have to do, why corporations have to do? Because the main purpose of commercial business organization is profit, to gain the profit. Why it has to take care of others? In my view, it's now absolutely necessary, because in this, in the current world of globalization, of mostly because of globalization, it gives value to reputation, to the competition status of the company, and it's just reasonable not to get rid of that part of the activity. If you want to be competitive, you have to do it. So back to the question whether the state is responsible and liable for the private actor. Recent sources, legal sources, draft articles on the responsibility of states for internationally wrongful acts, report by United Nations International Law Commission of 2001. It's an instrument which is not binding, but very highly recommended by the General Assembly of United Nations, and which was referred as a source in many subsequent court cases. The second recent instrument is Maastricht Principles of Extraterritorial Obligation of States in the Area of Economic, Social and Cultural Rights of last year. This is the work undertaken by professors and different law societies. And in this instrument, one can find the criteria when the state is deemed to control or not control the private actor. And one of the recent cases of European Court of Human Rights, it's Kotov versus Russia, delivered by Grand Chamber. This is really a piece of art, I must say, provided by the European Court. And in this judgment, you will find the recent approach, or maybe most modern approach, which is followed by the international community nowadays. Finally, the main principle is state is not released from international duty in human rights if it is performed by private actor. State is still liable. The question, of course, on what ground? On the positive obligation or on the negative obligation? So what are criteria for control? How to define? I mentioned 100 shareholding belongs to the state. the court practice says it's not necessarily such company agent of the state. It's not necessarily deemed that the state controlling such company. Or if the company is 100% financed by the state, whether it's controlled by it or not. In Kotov's case, the question was whether a liquidator or арбитражный управляющий, bankruptcy manager, administrator, can be deemed as a representative or agent of the state, remembering he is performing public function and remembering he is nominated by the court, meaning by the state through the court. And the first section, by unanimous decision, decided that yes, liquidator is a representative of the state, and the state is to be liable on the basis of a negative obligation. The liquidator is acting as the state's agent, where the Grand Chamber made a reversed decision, and again by unanimous votes, and now by 17 votes. No, the judgment states the liquidator, regardless he is performing the public function, regardless the fact he is nominated by the state agency, by the court, he is not the agent of, he is not public agent. The courts and the instruments I mentioned to you, they use different groups of criteria: institutional criteria and functional criteria. Institutional qualification under national law, whether it's the state company or it's the private company, how the domestic law sees it. Conditions for start-up and cease of activity, whether the state can start up and cease the activity. Who makes the decision? State financing, level of margin of appreciation in decision-making. How free in decision-making are the managers of the company? Functional criteria, nature of the activity, for instance, if it is providing of utilities to the town, it's deemed as to be a public function. Or on the liquidator activity deems to be a public function. Next, functions and authority towards third parties. Whether this corporation or private actor is authorized by the law or by practice afforded by the state to make decisions which are obligatory to the third parties. And one of the examples given in the literature is when the private security company, firm, providing security service to private jails. And then next, whether the authority, the special authority, is delegated by the state or it is not, and in what way. Set of the criteria varies from case to case. There is no exact answer. There will be lawyers like, some of us like black and white, some not, because it gives us more flexibility and it keeps us busy. But for this particular issue, there is no direct answer. And it decided from case by case basis. The courts also follow different sort of concepts of what the control means, starting from effective control, full control, and pure decisive influence. In the recent cases of European Court, even decisive influence can amount to the conclusion that the state controls certain actors. Okay, now best practices sharing. So a few words about my company. It's really an international company. We are represented and acting in all continents, now also in Africa and in Australia. It speaks in many languages. And this in EMEA, in European region, were again represented in all countries, and that gives us the right to say we know what all companies or what all countries share, what is the common value for all the nations. And the answer is human rights. Human rights are important because this is the values which are shared by every nationality and against which the company behavior can be benchmarked. Now, remember, social corporate accountability, it's the behavior above the law. It's not what is necessarily required by the law. It is what the company thinks is the right way to do. We have a number of initiatives to address the typical risk for pulp and paper business. And this risk in the area of environment, health and safety. We might be dangerous for people's life. We might be dangerous for people's property. And to address this, again, apart from following the legal requirements, we launched a number of initiatives. One of those is LIFE program. It's abbreviation of the idea life-changing injury and fatality elimination. I personally amazed how people perceived in the organization this concept. Initially, workers were telling, why do we need this? Why do we need to wear helmets and to wear special jackets? And now in the mill you can hardly find anyone without the jacket and without special stuff protecting. Sustainability program. Our industry is perceived as the one who is cutting the trees, but that's not true. You cannot believe in that. But for every tree we cut, we put 3 extra to recover. It's not required by the law, but we do it. Compliance and ethics. I can show you this. Oh, excuse me. This book, which is called Code of Business Ethic, which is in Russian and in English, which every employee has as his table book, and which is a part to the labor contract. For us lawyers, what does it mean? It means it's an obligation. And it says it does not repeat what is in the law. It repeats some typical situations which may the person face in his day-to-day business life with answer how he or she should behave. Then compliance and ethics and social program to develop community. We have pretty the same programs as my colleagues described on contributing to the social life and supporting the community. Any initiative won't be alive unless you have necessary processes and unless you have necessary resources. And one of those is the company in its objectives specify all these initiatives. And in every department, in every individual, including myself, I have KPIs which are linked to EHS activities. If the company has fatality, for instance, unfortunately it happens from time to time, my bonus, my reward is affected. So it's really when the person goes through the corridor and sees something is not complying with the rules, with EHS rules, he personally is interested to make the other following the rules. Then internal policies and regulations are approved by the senior management. Norms and standards are normally stricter than those in the law. Regular internal and external audits and revision by senior management. At each monthly management meeting, we are having business scorecards part of those which are matters relating to EHS, and all the time we discuss where we are, what is room for improvement. There is dedicated department and dedicated attorney who is specializing in this area. And interesting and not usual tool for Russian companies is a helpline system. Helpline system allows anyone, including any person in this room, any employee, to report on alleged violation of ethics and company and legal regulations which he or she thinks was admitted. It can be done on anonymous basis, and the company, if it sees it's reasonable, will have to investigate. And if it's confirmed, then immediate actions must be undertaken. I would like to come back, Birgit, to your question on spending and shareholders' rights. How indeed we can afford spending all these resources in order to do what is not required by the law? What is our shareholders' attitude to that? Shareholders like that because they understand it's in this environment of competition it is necessary to do. And last but not least question, why are lawyers? What is the lawyer's role in all this? We have to make sure our business desires, or desires of our businesses are working and they are enforceable. Thank you very much.
Thank you very much, Andrei. And I apologize that you had so little audience, but I think it's already late on Friday afternoon. But thank you very much for this very excellent presentation. Do we have any questions, any comments? I think there are a lot of fundamental issues raised, in particular liability issues, extraterritoriality issues, which are each deserving a separate presentation because they are really crucial to this kind of hardcore issues, expanding soft items. But unfortunately, we are running out of time to really cover all these issues. But I hope that there will be possibilities to dwell on that, because this is extremely important in this entire CSR debate, that we have a combination of hard tools like extraterritorial application of national laws and soft tools which are massaging those parts of the soul which are not hit by the hard law. Any comments, any questions for Andrei, or are you totally tired now after this Friday afternoon session? No, then thank you very much for staying with us, and I hope that you enjoyed the discussion, and thank you to all the speakers for coming and for all of these absolutely excellent presentations.